Good evening, everyone. Welcome back to another installment of the Voluntary. Uh, this week we are going to have sort of part two, a follow-up to the previous uh, segment on anarchy. Um, Today we are going to try to answer at least one of the fundamental questions that would arise about an anarchist or voluntarist order of society. So, and we've talked at length about property as being a fundamental societal building block. You know, we have to have. We've talked about how you have to have a standard of property in order to survive, in order to live. You have to have a standard to judge whether it is just to do a thing before you can do it, and people have to appropriate physical goods like food and water and shelter in order to simply survive. So you have to have a standard which can accommodate that in order for it to be functionally possible, and it has to be fair in the way that it treats everyone, so everyone has to have equal rights. We've already discussed at length about how capitalism is the only system which does both, which is both functionally possible and is fair in the way that it treats all of its participants. But now we're going to talk about in a capitalist order how dispute resolution could possibly occur when everyone has equal rights and there's no single authority to lay down the law. So resolving disputes over property is an essential part, or even perhaps the essential part, of any society. You have to have you have to be able to resolve disputes over what scarce resources belong to who in order for society to function. If you don't have any resolution like that, then the default is going to be, who can keep it, who's the strongest, who has the most friends, who can keep everyone else away from their resources, and that is in a sense, the true anarchy with no rules. What most people would think about when they hear the word anarchy, there being no rules. But when property claims are made, undoubtedly some of them will conflict. Some people will lay claim to the same property, and therefore you have to have some standard, again, which can determine whose claims, if any, are just, and whose claims, if any, are unjust. We have already covered that the only non-arbitrary and functionally possible assignment of property rights is capitalism, or property rights based on labor and mutually consensual trade. I have also made clear that the only systems of governance consistent with that standard of property are mutually consensual as well. In other words, that capitalism implies anarchy, better termed voluntarism. Now, to most people who don't have my perspective, immediately that sort of contention would arouse some crucial, very insightful questions from a perspective accustomed to hegemonic justice handed or doled out by the state, or as we know it, justice. First among them is probably this: how could our society, dominated as it is by the complex trade relationships that make high standards of living possible, exist without a grounding legal standard which defines property for everyone? And in shorter terms, isn't the centralized production of law necessary? And I use that term production of law because, in a sense, law is a service, just like any other service that can be produced, and any other good, any other service that people want and that people have to acquire. Law is a service, and therefore there are entities in society which produce it, and not the government is one of the entities that produces law, but there are others like insurance companies. The American Arbitration Agency, or AAA, is one such insurance company, and it was designed from the ground up specifically for the purpose of avoiding disputes taking place in the public court system, the state court system, because it was too slow, too expensive, too time and resource consuming. And so the American Arbitration Association, among others, were organizations designed to fill that gap in order to make production of law more efficient. And so in a sense, that's already an argument in favor of the production of private, mutually consensual law, that it will be more efficient. We already see that in our day-to-day lives. But obviously, the American Arbitration Association doesn't have nearly the same scope of problems that it addresses as the state does. And so really the question is then, how would it possibly cover every single aspect of our lives in order to make every possible property ruling? And that's what I want to talk about today. And if the state were voluntary in its membership, in a sense, it would simply sell a service for a yearly fee that we pay by April 15th, like any other subscription service. It wouldn't be any different. The thing which distinguishes the state from any other producer of law is specifically that contributions to it are involuntary. But in truth, the idea that that the production of law is centralized is not entirely true. Even if it were true, we would still be able to have historical evidence of a time when it was less centralized and it still functioned. So we could look back in history at, for example, maybe even the monarchist or the feudal days of history, and show all of the many other sources of law which have since coalesced into the state. All of those other sources of law that functioned, or at least coexisted, even if they may have had aggressive intentions toward one another, they at least coexisted in a semi-stable fashion for a very long period of time. And so it is far more centralized now than it was in centuries past, but even now there exists some degree of decentralization which can help to answer that question. Now, Murray Rothbard, who I actually have two of his books back here, Man, Economy, and State. Well, actually, this is Man, Economy, and State, and Power and Market is in the back, and then The Ethics of Liberty. That's actually three of his books, but two of them are in the same volume in my copy. So Rothbard puts it this way in his Power and Market. Quote, "The laissez-fairist, who is someone who believes in a general ethic of capitalism and free trade, but still assumes that the state is a necessary part of society in order to mediate all of those otherwise capitalist transactions." It's a much more common position than obviously a voluntarist position would be. But the laissez-fairist assumes that there must be a single compulsory monopoly of coercion and decision-making in society. That there must, for example, be one Supreme Court to hand down final and unquestioned decisions. But he fails to recognize that the world has lived quite well throughout its existence without a single ultimate decision-maker over its whole inhabited surface. So, over its whole inhabited surface, the Argentinian, for example, lives in a state of anarchy, if we were to use that term, a state of anarchy, or of non-government, in relation to the citizen of Uruguay, or of Ceylon, which is Sri Lanka. And yet, the private citizens of these and other countries live and trade together without getting into insoluble legal conflicts despite the absence of a common governmental ruler. The Argentinian who believes he has been aggressed upon by a Ceylonese, for example, takes his grievance to an Argentinian court, and its decision is recognized by the Ceylonese courts, and vice versa if the Ceylonese is the aggrieved party. Although it is true that the separate nation-states have warred interminably against each other, the private citizens of the various countries, despite widely differing legal systems, have managed to live together in harmony without having a single government over them. If the citizens of northern Montana and of Saskatchewan across the border can live and trade together in harmony without a common government, so can the citizens of northern and southern Montana. In short, the present-day boundaries of nations are purely historical and arbitrary, and there is no more need for a monopoly government over the citizens of one country than there is for one between the citizens of two different nations. It is all the more curious, incidentally, that while laissez-faireists should, by the logic of their position, be ardent believers in a single, unified world government so that no one will live in a state of anarchy in relation to anyone else, they almost never are. And once one concedes that a single world government is not necessary, then where does one logically stop at the permissibility of separate states? If Canada and the United States can be separate nations without being denounced as being in a state of impermissible anarchy, why may not the South secede from the United States? New York State from the Union, New York City from the state. Why may not Manhattan secede? Each neighborhood, each block, each house, each person? But, of course, if each person may secede from the government, we have virtually arrived at the purely free society, where defense is supplied along with all other services by the free market, and where the invasive state has ceased to exist. I'm going to stop the quote there for a moment and say this is pretty much where we ended off last stream. I phrased that argument very similarly to Rothbard's, trying not to plagiarize, of course, but I think he phrased it very elegantly, and there's not really a way to make the argument without making it sound similar to his writing. But again, that's essentially where we left off. That if you admit that a one-world government is not necessary in order to avoid a state of anarchy, it's difficult to create a logical stopping point where you allow the anarchy to end. And quite simply, there isn't a place for that to end. You either end up with full communism ruled over by a single centralized world government, or you end up with free market capitalism, voluntarism, which has no centralized state government at all. So, continuing on for just one more paragraph with the quote, the role of freely competitive judiciaries has, in fact, been far more important in the history of the West than is often recognized. The law merchant, admiralty law, and much of the common law began to be developed by privately competitive judges, who were sought out by litigants for their expertise in understanding the legal areas involved. The fairs of Champagne and the great marts of international trade in the Middle Ages enjoyed freely competitive courts, and people could patronize those they deemed most accurate and efficient. So, this ties back into the point that I was making earlier, that in centuries past, the production of law was far less centralized than it is now, and it would be absurd to suggest that decentralization is impossible from the state that we are now in, because we can point to many situations in the past where it was at least less centralized. Even if it wasn't completely decentralized, we can see that there's at least a path backwards to where we once were in history, to where it actually did work. So Rothbard makes that point. Now, let's get into the weeds a little bit. Now, in a situation where two individuals are customers of the same court, because it sounds a little strange to use the word court in the context of a customer, but Rothbard suggests that the courts and police may be run by insurance agencies in the voluntarist society because it's in their interest to in the insurance company's interest to reduce crime as much as possible, and so they would probably fold that into their business model if that became necessary. It's difficult. He compares in his Power and Market. He compares the trying to predict the structure of a voluntarist legal society. Trying to predict it exactly is like trying to predict the structure of the television market from 50 years ago to today. It really wouldn't be possible because you wouldn't be able to fully predict the innovations and the advancements that would come out in the production of law. So we can make some initial assumptions, but we can't necessarily flesh out every single aspect of the entirety of society. That's simply an unrealistic standard. We can only look forward to a specific, maybe a certain basic outline of what we should strive for now, and then we could fill out the details later, as so long as we're being logically consistent within our own principles. So that's what we're going to try to do today, is to simply create a basic outline of what we're looking for, or what I'm looking for, what you're looking for, depending on whether you're convinced, may or may not be a different standard than what I'm looking for. But this is what I'm looking for. So let's look into that. In a situation where two individuals are customers of the same court, the legal relationship between them is clearly voluntary, and any lawsuits between them may proceed without issue. Agreement on a court between two individuals is perfectly possible, as happens today, when two people agree on the same, when two people are customers of the same insurance agency. If that just so happens to be the case, then any situations between them will be handled internally, and that's how it goes. But in that situation, education and law enforcement might not look all that different from the modern state law, except of course that the two individuals are voluntarily joined under one law, and therefore may voluntarily separate, provided that the separating individual is not trying to skip town and avoid enforcement of a verdict. Enforcement of a verdict has to occur, because if a verdict was passed against you and then you just decided, well, I'm not a part of that law anymore, I'll just it doesn't apply to me. You really can't say that, because in the past you agreed to subject yourself to those verdicts, and then now you renege when you find out that there's actually a verdict coming against you. You would effectively become the origin of the term outlaw, that's where it came from. I believe it came from medieval Iceland. Was one of the first times that the word outlaw, or a word meaning outlaw, was used, because back then in medieval Iceland the law was really much more similar to a common law, something that was there wasn't a central figurehead like a king until after the medieval period in Iceland. And so during this time, the law was much more like a common law. It was built up on ruling after ruling after ruling, and the lawyers would look back on previous precedent and try to make their case. That's how common law works today as well. But in that period, the chieftainship was actually a piece of private property, that was a title that could be bought and sold, and the people who were under these chieftains were voluntarily under those chieftains. But the situation that you found yourself in, if you weren't under one of these chieftains was you were an outlaw. Literally, you were outside of the law. And so if you're outside the law, then if you don't subject yourself to those verdicts, then you also don't get the right when somebody comes to aggress against you or your property. You don't have the right to sue them under the law. You don't have the right to get a verdict passed against them in order to have them punished because you didn't submit yourself to the same treatment. And so that's really what it would look like. That's what your situation would be in a voluntary society. If you don't have a law, then you don't have the rights that come with being under the law. So, if you try to skip town, then you become an outlaw and you lose, basically you lose your property rights. Anyone can do anything to you without any consequences. Which is obviously a situation that no one would want to be in, and so I think the voluntary, there would be quite a great deal of impetus to put yourself under one of these voluntary contract laws. Not anyone in particular, of course. No one would have the right to force you to be under a particular law, but there would be an impetus to get into at least one of these contracts. And what we're going to look into next is what would happen if two people don't necessarily agree on the same law, if they don't agree on the same court. How could such a situation be handled anyway? Now, clearly, the situation here on the slide, if both individuals consent to this situation in the court, then the situation between them is voluntary, and any lawsuits that occur would occur without issue. But what if two individuals do not agree on a common court? So one individual consents, but the other one doesn't, and so there's no consensual relationship between them. Obviously, under a single court, this trial cannot proceed justly. Rothbard, in his Power and Market, has yet another answer to this shortly after the previous passage. So the situation looks like this. If you have two individuals who agree on, who have one court each, you have one court and one person, and one court and one person, but they don't, you see these red arrows mean they don't agree on each other's courts. Let me read the quote from Rothbard again. Suppose that Jones subscribes to Defense Agency X, and Smith subscribes to Defense Agency Y. We will assume for convenience that the Defense Agency includes a police force and a court or courts, although in practice these two functions might well be performed by separate firms. So you could have one firm that specifically does the enforcement, the police and detective aspects, and the finding of fact, and then you have might have another firm that specifically does the adjudication, the more lawyerish aspects of it. For convenience of the argument, we're assuming that all of that is wrapped under one agency, but again, it could occur under separate firms. We're again, trying to predict those details is not particularly possible, but we can make broad strokes for the sake of argument. So we'll assume for convenience that the defense agency includes a police force and a court or courts, although in practice these two functions might well be performed by separate firms. Now, Smith alleges that he has been assaulted or robbed by Jones. Jones denies the charge. How then is justice to be dispensed? Clearly, Smith will file charges against Jones and institute suit or trial proceedings in the Y court system. Jones is invited to defend himself against the charges, although there can be no subpoena power, since any sort of force used against a man not yet convicted of a crime is itself an invasive and criminal act that could not be consonant with the free society we have been postulating. If Jones is declared innocent, or if he is declared guilty and consents to the finding, then there's no problem on this level, and the Y courts then institute suitable measures of punishment. But what if Jones challenges the finding? In that case, he can either take the case to his X court system, or he can take it directly to a privately competitive appeals court of a type that will undoubtedly spring up in an abundance on the market to fill the great need for such tribunals. Probably there will be just a few appeals court systems, far fewer than the number of primary courts, and each of the lower courts will boast to its customers about being members of those appeals court systems noted for their efficiency and probity. I'm going to pause. The appeals court decision can then be taken by the society as binding. I'm going to pause the quote here again and say Rothbard here is taking essentially that there's being two layers to the court system. You have the lower courts that do rights enforcement and that do law enforcement and that do the judgment. So there's one lower court system, and then there would be another higher court system which handles appeals between the lower courts. So if two people are of different court systems, their individual courts can still come together, collaborate, and pick an appeals court in order to handle the situation between them to try to get those two legal situations sorted out in a way that is unbiased between each of them. And we're going to get into what happens when you try to introduce bias into the argument. But let me finish the quote here. Indeed, in the basic legal code of the free society, there probably would be enshrined some such clause that the decision of any two courts, and this is important, the decision of any two courts will be considered binding, i.e., will be the point at which the court will be able to take action against the party adjudged guilty. Every legal system needs some sort of socially agreed upon cutoff point, a point at which judicial procedure stops and punishment against the convicted criminal begins. But a single monopoly court of ultimate decision-making need not be imposed, and of course cannot be, in a free society. And a libertarian legal code might well have a two-court cutoff point, since there are always two contesting parties, the plaintiff and the defendant. End of quote. Now, the reason that he uses a two-court cutting-off point here is we're going to get into next. The two-court cutoff point is logical for the following reason. Suppose that Jones and Smith are totally selfish. They have no conception of justice outside of whatever they can get for themselves. You know, the only reason they haven't resorted to violence at this point is because violence is expensive. It would be easier for them to sort it out through the court system. It doesn't diminish their social reputation. It doesn't, like resorting to violence might, because of course you have the possibility that other people would see that and regard you as a threat. You also, if you resort to violence, you have the possibility that the other person then will then open a suit against you, will open or may just counterattack you, but he may countersuit against you, and then if you commit an act of violence, you could find yourself being criminally prosecuted as well. So violence under the system being taken up into the plaintiff's own hands probably wouldn't occur very often. Of course, we would consider it, depending on his plight, depending on whether his plight was just or not, we may or may not fault him for doing that, but it wouldn't happen very often. Of course, the specifics of the situation would have to be analyzed in order to determine whether his use of violence was just or not. But it probably wouldn't happen very often because it's easier in both in a social sense and in a physical risk sense to sort that sort of thing out with words in a court of law rather than with blows. So the courts essentially provide a cheaper and safer and more socially acceptable way to resolve disputes other than physical violence. And they do in any society, but that's especially what they do here. The two court cutoff point is logical for the following reason. Suppose that Jones and Smith are totally selfish and choose courts which will always rule in their own favor. Now, this could have been done through bribery, this could have been done through blackmail. They might have just gotten their friend who had a bunch of other really strong friends to just... Maybe they didn't even bother with a trial. Maybe they just wrote on a piece of paper that says the verdict is Jones is okay, and also Smith owes us $1 million for the trouble of getting together and deciding that Jones was okay. Anything of that sort could happen, and that would essentially that wouldn't really be a trial. That would just be them deciding to commit violence against Smith. But suppose that these courts somehow they've convinced them to rule them always in their own favor. Essentially, that's fixing the verdict. Now, once a verdict is given, it can be appealed by the defendant in an appeals court to which both lower courts subscribe, or one selected on the spot by both courts if no prior choice exists. That's a pretty important dynamic there as well. When the two courts have two different verdicts, so if one finds Smith, if Jones's court finds Smith guilty, and if Smith's court finds Jones guilty, then obviously there's no way that those, or maybe if Jones' court finds Jones innocent and Smith's court finds Jones guilty, there's no way that you can reconcile those verdicts. And so probably what will happen is that they will resort to violence unless they go to an appeals court, which both courts agree on. They could either agree on that in advance, which appeals court such a situation would resort to, or they can select one on the spot, so long as there's some kind of a deliberation between both courts and it's not a unilateral decision by one court or the other. Now, look at what happens when both courts are required to submit to this decision making of which appeals court is to be picked. Now, since both courts subscribe to the same appeals court in this case, it would be impossible for both bribed courts to consistently get appeals ruled in their client's favor. Because if Jones's court always gets a ruling in favor of Jones, and Smith's court always gets a ruling in favor of Smith, obviously the appeals court that they've selected can't rule in favor of both Jones and Smith at the same time. And so the appeals court has actually got to consider the situation, has actually got to figure out who's in the right. So, of course, bribery of both a lower and the higher appeals court is possible, but whereas the lower court might only have the one customer, the lower court might just exist as a front for Jones, as a front for Jones trying to pass his own verdicts on the rest of society. The higher court has a lot of customers. The higher court has a lot of lower courts underneath of it. So if the higher court was found taking bribery or making slanted fixed verdicts in favor of one client or the other, it's worth remembering that it has no monopoly on decision making. It's not the only court in the market, and so it might lose its customer if its bribery were found out or even suspected. We see that all the time when there's suspected impropriety with a company's finances today. People or companies that are suspected of fraud, selling fraudulent services, they don't keep their customers. If they sell a bad service, they don't sell any of that service. And so the higher courts would be subject to the free market in that case, and courts which were capable of taking bribes would quickly go out of business. If the market were allowed to work in this area, better and more certain justice could be dispensed than is now. So under this 2 of 3 courts scenario, if the appeals court rules in favor of Jones, then at that point, everyone who's watching that situation would then be able to say, what was the verdict that was passed? What was the verdict that came out? And then if it was found against Smith, then they wouldn't have any business in that verdict. They wouldn't care because Smith is a criminal. Smith deserves what's coming to him because he was judged guilty in 2 of 3 courts. But if the verdict instead came out against Jones and Smith was a non-criminal, but Jones went ahead and aggressed against Smith anyway, then it would be clear that Jones was the criminal in that situation, and there wasn't any justice dispensed by Jones against Smith. It was an unjust action. And so it is possible, again, we can't necessarily predict all of the things that will happen under a voluntarist order of law. But, as I've tried to do tonight, we can lay out a basic outline in order to give you a mental picture of how this sort of thing could occur, even when all of the participants are voluntarily united. Justice can still happen. Verdicts can still be upheld as just, and therefore this isn't to say that the system is completely impervious to bribery, but I think the history of bribery on the free market is much more bleak than the history of bribery in monopolistic settings, in where the government is permitted to make the decisions in that area. So, with that, I think I've pretty much run out of material, but are there any questions this evening from the audience? So, really, what the basis of the entire the basis of the entire legal system is based on everyone understanding what the libertarian ideal of justice is, which is obviously capitalist, that everyone owns their own property and no one owns anyone else's property, so that when justice is being dispensed in that case, it's obviously risky for someone to take justice into their own hands outside of the court system, but it's not risky for the same reason that it is now. If you take justice into your own hands under the present statist system, you risk becoming a traitor. You risk usurping the law, the centralized law which now exists. But if you take the law into your own hands under a libertarian law code, then the only thing that you risk is becoming a criminal in the eyes of other people and in the eyes of the person who might countersue you. So keep in mind even that this libertarian law code applies to the judges in this case. So if the judges, for example, passed an unjust verdict, for example, if Jones had assaulted Smith, but the judges said that the penalty for Jones would be death, and so they want to chase him down and kill him, that would be unjust. That would be over and beyond the crime that was committed against Smith, and so they themselves would be subject to criminal suits from other people in the society because they themselves would have to live under the law. And so Jones or Jones's heirs, if he did end up getting killed, Jones's heirs would take up that against them and then would be able to countersue them. So that's part of their incentive to have a just bribery-free verdict, because they then have they then remain as non-criminals, as operating legitimately, and so that keeps their records clean as they do their business. So, did we get any questions in that time period that I just took up? So, seeing no questions, we're going to go ahead and wrap it up here. It's been a pleasure talking to you all. And have a good evening. We will see you again this next Saturday at 8 p.m. And we will be talking about something else related to voluntarism. I'll see you then.